I'm going to start the webinar now, so we will be live. Should be recording. All right. Hello, everyone. Looks like we're at the top of the hour, so let's go ahead and get started. Before we get started with today's Around the Valuation World webcast, I want to go over a few housekeeping items. The first item is to receive CP credit for today's webinar, you'll need to respond to all the poll questions that pop up on your screen throughout the webcast. CP certificates will be available in your nacb.com portal if you have a subscription, and it will be available within 7 to 10 business days. If you have any questions during today's webinar, please feel free to use the Q&A option in Zoom to ask the presenter a question. If you have any questions about NACB or any technical questions, feel free to use the chat feature, as those will be directed to me. Right. And then with that, I'm going to turn the time over to Mel and Alina, who will get us started for today.
All right. Thanks, Trinda. Welcome to everyone. I hope you're doing well. Welcome to this this month's program for the Around the Valuation World. We just came back from the conference in Fort Lauderdale, and most of us survived not getting blown away with the winds there. So we have got a great lineup for you again this month. We're going to start off with Michael Gregory, which is always a favorite segment, talking about industry headlines and things that you can go deeper on. But then he's going to step into talking with Greg Caruso about the size element in valuations, valuation of small and micro businesses. The next segment will be with our judges, and Melissa Gragg is going to take that on with the judges and go through some federal rules of evidence stuff with us, which is going to be really informative, always great. And then we have a special segment on an economic update. Janae, Castell, Simon Rubinsohn. Now, this is a recorded segment primarily because he had a conflict, but it is always so informative that we're going to bring to you. And then Michael Mulder is going to bring in some case law. And then Brien Jones is going to be interviewing Michael Hill, talking about how to protect your business and E&O and potentially a new member benefit there. So with that, what I want to do is introduce the first segment, Michael Gregory. He is a regular contributor to the AVW. He is a regular resource to the members of NACVA and does a lot of work in the valuation, mediation, communication space, and just a wealth of knowledge. Michael, good to see you in Fort Lauderdale. Good to see you here, my friend, and welcome aboard. I'll let you take it away.
Well, thank you very much, Mel. We have a number of articles we're going to go over here today. The first one starts off with BV real estate gap regarding property rights can skew your valuation. I was a real property valuer for over 20 years, as well as being a BV valuer now for over 30 years. And there are differences between those, and there's some things you need to be aware of relative to real property. More AI woes add to cautions. Stories are key in BV, including in job postings, the story of your firm and how you bring that across to others. The number one valuation issue that triggers an IRS audit. Kitchener goes after another BV myth, and several industry reports of note with a fair number of references here today. So in terms of what our objectives and main takeaways are, identify real property issues for asset-based entities, distinguish AI cautions, apply stories to BV recruiting, identify the number one BV IRS trigger on an audit, assess what is known or knowable, and recognize 3 new industry reports. So the first item, this is from the 2023 ASA International Conference, Insights by Barry Cunningham. He's with Property Tax Research LLC. He commented that when you have an entity that you're primarily, the assets are the valuation. The assets are real property. He gives examples: nursing homes, golf courses, hotels, could be commercial buildings, apartments, whatever. But you need to know the difference between fee simple versus least fee. And what does that mean? There are oftentimes misunderstandings with respect to the intangible values. And if there are rents, are the rents at below value or above market value? What is fair market value for the rents? There's an article that I have here for your reference on this topic. But the key is, unless you are a real property appraiser, this is not your area of expertise. You need to push back at your client. We need to bring on board a real property valuer that has access in that area. That's the nuts and bolts of this article, and it's pushed back to you. More AIOs add to cautions. And I'll comment, I was at the conference in Fort Lauderdale, and I heard emerging technologies and ethics from Dr. Sridhar Ramamurthy. And he presented a number of things, and I left with something that to me is going to be right on point. I blog weekly, and I'm going to leave this with when I blog, and I have some SEO people that help me, and they have started using AI to produce blogs. And they put one on, and I said, hey, who wrote this? And they came back and said, well, Kathy. And I said, who's Kathy? They said, well, Kathy is just an avatar. She's not a real person. I said, I don't want to post this. So I took it down. But now I listened to the comment on ethics, and he said, no, you can still post that. What you want to do is you want to identify at the bottom of the article that this was produced with the assistance of AI. So I went back to the folks who posted that, and I said, we can post that now, but I want to put that caveat on the bottom so we can distinguish what I write on my blog versus what AI writes on my blog. So this is a continuing work in process, but that's something that I learned from last Friday. In this case, the client was suing an attorney for faulty closing argument written by AI, and 50% of lawyers expect to use AI within the next year. Now the question is what you do with it and how you let your clients know that you're using it. If you use AI, you need to check everything and consider internal policies about when and how to use it. Then you also have to consider confidentiality issues with respect to what's written there and what might be used in the future. Stories are key in BV, including in job postings. And I thought, oh, I hadn't thought about that in job postings. But of course, you want to have a good BV report that tells the story and ties into the numbers. You also want to think about that when you're doing a job posting about the story of why your firm, why is your firm different? Why would you want to work there? Do you have better balance? Do you have diverse topics to work on? Do you work on development of employees? And you can ask your staff, why do they like working there? And that may give you some additional ideas, and then include those in your job postings. And John Borman has a posting on this, and we have a link to his comments. The number one valuation issue that triggers an IRS audit. This is from the ASA International Appraisers Conference, November 3rd in New Orleans. And I was a speaker there. And I reached out to the BV people at the IRS. I have over 70 contacts, and I got feedback from a half a dozen different people. And they came back and said, well, we are now involved in a number of different things, including they're looking at what takes place with various intangible valuations and looking at the same kind of things that are relatively new to our valuation world. But they also said discounts for lack of marketability, discounts for lack of control. And they cite an article that indicates they've heard the same thing from other IRS people, besides Mike Gregory saying this. And I critique IRS reports with different concerns. I don't do a thorough review. With my concerns, I look at reports and I say, what do I think the IRS might look at here? What are things you might want to shore up? And here's how to shore them up. Maybe you want to take something else that might be a negative from the IRS's perspective. And there are complimentary ebooks at my website, one of which is a book on how to write reports for the IRS. And that's available for free at mikegregg.com. Kitchener goes after another BV myth. And the BV myth, what does know or knowable mean? What does known or knowable mean? And he runs through that. You look at this, there are several different definitions to what that means. And there are different definitions within different court jurisdictions. The U.S. tax court has its own little definition that it uses. And it came to Kitchener that only as a surprise, only the AICPA deals with this directly. No other standards do, although it does tie into Revenue Ruling 5960 and AICPA BV standards and other sources. And he comments that if you look at Gary Trugman's book, Understanding Business Valuation, the 6th edition, he has a nice section on known or knowable. It would be a great reference for you if you need to obtain further information on that. Then there are several industry reports that I have links on here in the back. The Food Monitor is published by D. Riley Advisory Services. and it's on very large and well-known companies in this area of food products and industry trends and market pricing. There's a value in here on focus on auto dealers. Mercer Capital mid-year 2023 data on sales, blue sky, on guideline public companies. And I'd comment, if you go to Chris Mercer's Mercer Capital website, they have a number of things there. It's a good reference source that if you haven't checked that out, you might want to check that out. Information on a number of different things that we work on in valuation. And then global software sector update. It comes out from the fall of 2023. Kroll is a very progressive firm. We'll have some information from some reports from Kroll next month here too. But they have a companion report on mergers and acquisition and what's going on with different entities and software that you may find to be helpful too. And then in terms of the sources, Property Rights and Real Property Appraiser, here's the ASA BV review. This is the article you can take a look at to give yourself some insights of what you should be asking, or if you don't ask, you want to push back at your client that they should obtain someone who has expertise here in the area of real property, whether it's fee simple or leased rights or what those might be. This is a John Barrowman job posting video. Makes recommendations that your firm tell a story when you're trying to recruit somebody. And so why they'd want to come and work there, why your place is different, and why you are a great place to work for someone who's looking to enhance their career. And then the complimentary ebook on reasonable compensation, that's just from my website. There are a number of complimentary ebooks there, but that's one specifically on point. And then Hitchner busts the BV myths. That he has a number. If you go to his website and you check out what Hitchner has written, there's a fifth or sixth one where he puts a myth up there and then he runs through with some detailed data to what's behind it. And it can be very helpful to you to look at some of those. Then Understanding Business Valuation, 6th edition by Gary Tregman. That was one of the things that Jim Hitchner brought up that you might want to go and take a look at. It addresses the issue of known versus knowable. And here's the Food Monitor by Riley and Associates. If you're involved in the food industry, you might want this to get some additional insights on the industry as a whole. And that may help you with what you're working on if you're working in this industry. On auto dealer industry, here's some information from Chris Mercer, and on global software sector, here's some input in fall of 2023. Well, these are the different sources that I use each month to present information to you. And that's my contact information. And if I can help you, I'd be more than happy to help you with anything you might have a question on, or if I can put you in touch with some other expert, I'd be happy to do that too. With that, we're going to switch gears a little bit here, but keep right on the same session. Here's your first poll question. You might want to click on that. And I'm going to bring up a dear friend of mine, our former editor, and someone that I have a great amount of respect for with his book, with his knowledge and his expertise. And that is Gregory Caruso from Harvest Business Advisors. As you can see, he's an attorney, a CPA, a ABV, CVA, and he's the principal with his firm. He's the author of the book, an excellent book, great source, The Art of Business Valuation, Accurately Valuing a Small Business. If you're valuing a small business, highly recommend that book. And it focuses on BV, small businesses, exit planning, ESOPs. He's in the New York, New Jersey area, and as the weather gets colder and he thinks about skiing, he's likely to head on out to Colorado. So with that, I want to welcome on board Gregory Caruso. Welcome.
Well, thank you, Michael. As always, it's a pleasure to be back. It's it brings back a lot of memories. So I always enjoy being here.
Well, thank you. We're glad to have you. And today you're going to be talking with us about size matters, valuation of small and micro businesses. You published an article in May, June in the Valuation Examiner, and you talked about when you're working with micro businesses, small businesses, it's a different animal, and there's some things you need to know. Do you want to talk about that a little bit?
Yeah, well, the point of that article, and what we're going to spend most of the time talking about today, is a way to select a multiplier for smaller businesses. I'm a huge believer in the market method. But I also have the caveat that it's much more effective. Sometimes you can find enough comparables for larger, but it's much more effective for companies with typically 10 million, maybe 20 million in revenues. Smaller businesses, just because there's sufficient data to use the processes that I'm going to show you that we'll talk about a little more today. So that's what makes this really work.
We're going to run through a problem together here that you had here in the article. But in
Yes.
general, you're saying when you're working with much smaller businesses, there is due diligence you can have with market data. That's part you're going to show us here today.
Yeah, and
So
then
what's the-
I'm sorry, the
I was
other
gonna say-
items on the slide, again, with the smaller companies, you have less. Our financial data is often much more questionable. There's nothing we can do about it. Frankly, if you think about it, if you value a lot of small businesses and you see what the data is, well, the compilations like RMA and everything else, well, where are they getting their data? The same small businesses. So at a certain point, you have to start applying a lot more common sense, really things we would always look at, but who are the people? Are things consistent? Some of the smaller things that are just presumed with larger companies.
You would like me to proceed on to the problem?
Certainly, I'm sorry.
Oh, no, that's cool. I'm here to help you, so you're doing great. So talk us through what's the problem we have here.
Well, here's the problem, and I've heard it a million times, and frankly, I used to experience it before I started doing this process I want to show you today. We have a well-run company, so this is probably a 75th percentile company in terms of financial results, in terms of the people, when you talk to them, they make sense, they know their jobs, they've got a reasonable number of subordinates for the size company, they're organized. One of my big tests is, can they get me data? If I ask a fairly straightforward question, can they get me data in an hour or the next day or 2 weeks later? Are they still cleaning things up? So it's 75th percentile. And, why is the revenue multiplier result so different than the seller's discretionary earnings result? Why does that keep happening if I go to like Deal Stats or anybody else and look up a 75th percentile business? And you can see here, this is a very brief summary, but you can see when I go to the 75th percentile, look down that line item, I have a multiplier of 0.53. This was an auto repair company. They do a service company. The SDE cash flow was 3.1. You could see that I had about $1 million of revenues and about 250 of sellers' discretionary earnings. Now, sellers' discretionary earnings, in my mind, is a shorthand for EBITDA, plus every way one owner makes money. I don't want to spend a lot of time on that today, but it is important that the cash flows be figured in the same way. And you can see if you go to the value found, there's a $200,000 variance, very, very large. Now, we don't have the final results slide like this, but I can tell you after we go through this process, the variance between the two is 32,000, a significant difference. And frankly, the value is much closer to $500,000. And we'll go on and I'll show you how I came to those conclusions.
Okay, so you start off with some comparable data search.
Yeah, so again, any market method, what we're doing is we're using comparisons, and I'm not looking for an exact match. I mean, I'd love it if I could find one, but an exact match is one price. A price is a negotiated, it involves emotion, it involves how good were your brokers, how desperate was one person to get this deal done versus the other. But when we get 20 or 30 prices, now we can start to determine a value, at least in my mind, with what we can know and not know about market data. So I use Deal Stats because for the size and types of things I'm doing, it's a very complete database. I've also worked with it long enough that I've learned to, really investigate things in a lot of detail. And that's just something anybody learns with any, with whatever product you use, for the various types, for the various method. I typically won't go back before 2013 unless I absolutely have to. Again, my theory on that is that's kind of when this last market run began. Obviously, it does have COVID in it, but in hindsight, COVID turned out to be a bit of a blip. Obviously, a few things got very changed by it, but for the market as a whole, and I'm typically now, and this is something different. You'll see these graphs are a little older. I'm ideally looking for 20, 25, 30 comparable points. And what I find is if I intelligently narrow down to that, my statistical measures usually indicate I've got more correlation, closer data that we like correlation. Humans like correlations. Evaluators love it. It also, in my mind, if I did the search right, when I'm doing the search, I'm trying to come up with, again, similar companies, similar size, similar profitability, because they probably are going to have similar management structures and a lot of other things going on by doing that.
Okay, and here's some of your data search continued. Here's some of the things that you found.
Yeah, this would be a typical search, and when I'm searching for similar companies, I will typically go 1/3 below my company's revenues and 2/3 above, because typically there are more comparables below. As the value gets higher, as the revenues get higher, the comparables start dropping off. I will look at, is it SDE or EBITDA? I find at about 400 to 500 of SDE. EBITDA probably becomes more meaningful. Remember, as evaluator, some of the most important decisions we make is what method do we use, and then within a method, what choices do we make? And this is just based on, I've done these things hundreds of times. And again, part of the issue is with EBITDA, I have to determine the owner's compensation, where if I only have one owner and I don't have to determine reasonable compensation, I think that's probably more logical. Because what is somebody that can do any role in the company between profit and salary, makes $400,000 a year, probably works 65 hours a week or not, and most of the places that you get data as to their compensation, they're being told what to take compensation wise, usually by their tax accountant, not by market forces, because they're on both sides of that deal. Sometimes I'll search for a keyword like franchise, and the reason I mention that one is if there's enough data, franchises usually sell for a higher multiplier. So again, and that's because if it is a good one, and they're not all good, but some of them are, if it's a good one, they do bring systems and stability to their franchisees. And then finally, sometimes you've really got to root around and slice and dice the data different ways. Sometimes there's not enough data with one NAICS code. Sometimes, I will just say, I will sometimes have to do 2 or 3 sorts right in deal stats and try to understand what's going on. Not typically, but certainly there are businesses where that is helpful.
And you said you use deal stats, and here's some of the reasons why.
Yeah, their statistics tab, again, has different ways to look at the data. They have a lot of statistical already organized. And frankly, I like the level of detailed data. particularly as it's getting newer, and maybe that's also part of my 2013. They do, nobody's perfect. They're getting the data from brokers. I was a broker. I know how little most brokers know, so there are issues there. But they are really working hard. I do know this because we also used to give them data, and they would call us up. One of the shops I was at, they sent 3 days data. I mean, they sent someone out for 3 days because they had a lot of files, and they actually manually went through the files with the brokers. So again, they're doing the best they can, and I also respect that.
And what does it mean? You said 75th percentile because this firm was doing better than others. What does that mean
Yeah,
in,
well,
in, in deal stats?
Yeah, the one thing I want to stress is, and I made this mistake for years, it's the way they lay out the data. They show a column of 75th percentile results. And it's very easy to believe that those results are all lined up. For instance, if I have a 75th percentile cash flow, that multiplier down there is the high end, not the low end. But it doesn't work that way. Each of those line items is analyzed on its own. So the reality, and everybody's gonna have a hard time with this, but I've done it hundreds of times, and we're gonna show you in a minute. On average, and again, every business, every NIAX code is different. That's why we have to do it over and over. But on average, the 75th percentile cash flow is probably better reflected by the 25th percentile column because how it works. So you just have to be very cautious if you're going down, that you don't assume that all of the numbers in the 75th percentile relate to each other, because they do not. And that's also part of why the market method with the revenues is so different than when you get a earnings type cash flow like SDE or EBITDA. That's part of the reason they don't all line up that way, even though it's very easy. And the data, if you really dig into it, it's clear. It says that this is what I'm telling you is what it says, but it's just so easy when you're rushing, or if you don't really know the database yet, to make these assumptions.
We'll run through some graphs here pretty quick, but they're telling. Let's talk about what's the first one here.
Yeah, can you jump down 2 slides? What we do first is we pull the data from deal stats, and these are just columns in their detailed data. And I will always search, or I will always search early on by a cash flow measure in addition to revenues, because then in my mind, all of my statistical data for that cash flow is comparable. But we then take these couple columns and we graph, and we create graphs out of it. And once you create the graph, you can reuse the chart to create the graph. So this only takes a couple minutes. It's not the first time, it's kind of a pain, especially if you're an old guy like me and don't know Excel really, really well for graphing and stuff. Now, if we can go back so this is the cash flow multiplier. In this case, it was seller's discretionary. And you can see we graphed the multiplier going up, and across the bottom axis, we have the profitability percentage. Now, our particular company had a SDE to revenues, a profitability measure of about 25%. And you can see that's, if you just go out on the trend line, and for purposes of this demonstration, we're going to assume the company's very close to the trend line. You can see that's at about, it's a little over 2, but we'll just call it 2 times for our purposes. Now, what I will also say, and if we have time, we'll get to statistical data, but you will see there's a very broad measure here. I did not limit the dots or the comparables as much as I would have nowadays when I did this one. But what you will see is this produces poor correlation. But this is real data. When you have poor correlation, what that means is there may be a reason why your company is going to be further away from the trend line. My personal belief, the reason we have such poor correlation with auto repair is because a lot of the auto repair have a lot of money under the table. I just hate to say it. And so now if we're turning in published financials, well, of course, there's going to be variations between what was published and what they sell for, perhaps. If we can now go down to the next one. Now, if you'll notice on the revenue multiplier, this is going the way you would expect. As the profit percentage is going up, the multiplier is going up. Again, it's the same thing. And if we go out 25%, we're at about 50%. I think it was 0.53 on our original data. So that was pretty close. But notice that this is as profitability is increasing, the revenue multiplier is going up. That makes sense. Now, go back to the one before, if we could, Michael.
Oh, okay.
Notice, and everybody says this can't be. I have done this 2, 3, 4, I have no idea how many 100 times. And it almost always does this. Why would the cash flow multiplier be getting lower as the profitability goes up? Well, and this is why I found this so fascinating, because when I sold businesses, which I got out of about 1.5 years ago, but I sold businesses, we would do the valuation and then go have to sell them. And I couldn't figure out why a great business with a 4 multiplier, I couldn't get that. I could only get 3. Well, what happens is you'll find if you look at the data, the poorly performing companies, you have 10,000 of cash flow, but you got a couple trucks, so you sold for 100,000. The guy bought your trucks. Well, that's a 10 multiplier. And in this case, I did a cutoff of cash flow, so a lot of those really skewed ones aren't showing up. But things like that start to happen. There become other assets besides the cash flow as the cash flow gets to be very small. But a very small cash flow versus a decent revenue base is a huge multiplier. So it actually starts to skew it. And that's what's going on. And that's the reason the market method, you get these 2 very different results, which gives the impression it's unreliable, which is why, I'm doing, or my staff is doing, at least one of these a week, because to me, it's the only way I can take the deal stats data and unless if I have a dead median company, well, it's probably going to be that number. But otherwise, you have to do these charts to get comfortable. And once you do it, you will see it starts to really make a lot of sense. You just have to use the data properly in order to get the results.
Hey, Greg, we got a couple of minutes left. I'm just going to take us on to this next slide, and you can go as far and as fast as you would like to go.
Yeah. Well, again, there's directions how to make those scatter plots we were just looking at in Google. If you Google it, there's some really good directions. I'm not going to try to go into it. It's not that difficult. I could do it. And then I reuse it. What I will say is, if you have an inventory company, look at the data very carefully. They have a lot of data. Also keep in mind, it's being submitted by brokers. If it just absolutely doesn't make sense, it may not make sense. But when did it close? How much inventory was included in the number if it's an inventory business? Are there other assets out there? So, people love statistics. I think they're helpful. Just remember, correlation is not causation. Any statistician will tell you until we've shown causation. While we love correlation, be very careful. If it was strictly causation, nobody would go to a hospital because that's where everybody gets sick. You don't get sick at the hospital. That's the difference between correlation. Yes, there's a lot of sick people at hospitals. Presumably, it's not where they got sick. And it's very easy to make that mistake. If it was as simple as statistics, a 16-year-old with a spreadsheet would have my job.
So why don't we just bring it home here with your major points here, Greg?
Yeah, again, you're trying to, sort by revenues, sort by SDE or EBITDA if you can get enough points, and you usually can. If you need to expand to some related NIAX codes, often there are related ones, and you can get a big enough search of companies that are similar. Remember, we're trying to get a cap rate, not an exact match. What is reasonable for this size companies with these industry risks in the market? Thank you. And yeah, I have some links there for places where if you did want to look into the graphing and don't know how to do it, some of those links were quite easy. They were very good links, at least at the time we published the article, for how to do some of these things in Excel.
If you have any questions, here you are. Greg Caruso is the man. He's a very caring person. He's a very considerate guy. So here's his contact information. Feel free to reach out to him. He'd be more than happy to help. And I want to thank you for being so gracious on being on the show with us here today, Greg. And we look forward to seeing you again in the future. Thank you, sir.
You are always welcome to reach out. Thank you so much, y'all. Bye-bye.
All right. With that, I'm going to pass it back to Elena, and you can take it from here, ma'am.
Thank you, Mike. Thank you, Greg, for being with us today. So for everyone, we have our second polling question. Make sure you respond to that. And then for our next segment, we have Melissa Gragg. She's one of our senior evaluation correspondents who has been part of this show since the beginning. Melissa is well known by most of you because she has been an instructor for the Training Institute and have served at the Litigation Forensic Board and the Executive Advisory Board. She specializes in business valuations, mediation, and collaborative divorces. And some services that she may provide are in person, and she also works a lot with online meetings. She works with other mediators to provide business valuation services when the value of a business is in dispute. So Melissa is going to be discussing with our judges today the amended Federal Rule of Evidence, that is the 702, and what valuation experts needs to know. So Melissa, hi.
Thank you, Alina. I appreciate it. And we do have Judge Yates here with us, and I'll go ahead and share my screen that will give us a little bit more background. No, there we go. Okay. So basically, this is a discussion that we'll have with Judge Yates, and maybe Judge Driscoll will also be joining us. But it's basically if you play in the world of expert testimony and you have traditionally kind of been used to this Daubert challenge or understanding what the Daubert challenge is, we now have kind of an amended Federal Rule of Evidence 702 that really is now creating like the conversation isn't necessarily a Daubert challenge anymore, but it's usually a motion to strike or a motion in limine to remove the expert. And so I thought that it would be a helpful discussion. And there is some information about us and about the judges. But in general, if we look at what was amended or conceptually what was the purpose for this amendment, I think that we'll get the judges' perspective first about like what should we really focus on as valuation experts in understanding the nuanced differences of this rule. And maybe Judge Yates can. We got Judge Driscoll. Okay, yeah, great.
So why is the rule here? The rule is here to give attention and really make trial judges focus on the importance of their gatekeeper function. It's not a fundamental. It's not a change in the law. It's just a change in the wording of the rule. The federal rules always required, when you looked at old 702 and Rule 104, always required the judge to find by a preponderance of the evidence these very factors here, A through D. And of course, D was just reworded. So there's really nothing new in the law. It's just a refocusing of the judge's attention. And if there are any civil procedure geeks on here, and I think it might just be Judge Yates and me, this is similar to Rule 26 of the Federal Rules of Civil Procedure being amended 8 years ago to stress proportionality in discovery. It was always there. It was just a reordering of the words. So those 12 words in that first clause of 702 have always been the law. But it's just the drafters of the rules said that judges weren't necessarily following that law. They were letting expert testimony in without that rigorous analysis of their gate and rigorous application of their gatekeeper function.
I think Judge Driscoll has it exactly right. And I think people may expect the amendment to mean too much. What I've always said is it's the same rule, except now it has an exclamation point at the end of it. There's a committee that drafts proposed rule changes. And I got to sit in on several members of that committee talking about the amendment. And they were very, very clear that this is not intended to work any substantive change. But as Judge Driscoll points out, it emphasizes the procedural aspects of the rule. First of all, as Judge Driscoll alluded to, there's a gatekeeping function for trial court judges. And there's a natural inclination of trial court judges simply to punt on questions of the expert's ability to testify, the qualifications, the methodology used by the expert, and whether the principles have been applied faithfully in reaching the conclusions being presented to the jury. A lot of trial judges simply say, look, it all goes to weight, not admissibility. We'll let the jury hear it, and then I'll figure out how much weight to give it. I think the drafters of the rule really don't want trial judges to do that. They want us to conduct Daubert hearings. And whether you call them Daubert hearings or 702 hearings, the point is that an expert can be knocked out before the trial even starts. Now, that is cataclysmic if the trial court won't let you substitute one expert for another. Ordinarily, when I was a trial judge, I'm now on the Court of Appeals, I would allow the substitution of a new expert if I disqualified somebody. But I think it's fair to say that the number of successful Daubert challenges is rather small. I think the rule drafters expect that number to grow, and we'll see what happens.
And I just saw a question in the chat feature that Michael Mulder put on, and I think it's exactly right that lawyers may now see the changes in Rule 702 as a license to bring those motions in limine to preclude. And I think that's right. And I think that's what the drafters wanted to encourage, to require the trial judges really to as we've said, exercise that gatekeeping function. So if the byproduct of it is more motions in limine to preclude, so be it.
Well, and do you project or forecast or predict that there's going to be certain types of areas that people are going to go after? Because I think even Michael Mulder had written an article in one of our news that, talked about what attorneys are going to try to do. Because I think that this is going to increase the number, increase this just as a part of your checklist to try to get rid of the expert. But we've also seen it happen in cases where there was not enough information, or if there was information that was excluded or something like that. Do you see an area where you think that this is going to be really prolific?
Well, I would.
I'm sorry. Go ahead, Chris.
That's good. I would say this. Daubert, in its original conception, was designed to get rid of junk science, and the filter wasn't supposed to be particularly tight. I've always operated from that philosophy, and I think most trial judges do that as well. So I think that the number of challenges will probably increase dramatically, but the success rate for the challenges, I don't think is going to get any better, and it may get worse as more and more of them are filed. We'll see how this all sorts out, but trial judges particularly when a case depends upon an expert's testimony, are loath to just disqualify an expert before the trial starts. If the expert's testimony is really that unreliable as to constitute what the Supreme Court described as junk science, I think most of the trial judges think that that will be exposed on cross-examination. But Judge Driscoll may have a different view of that than I do. I just don't think that Daubert was meant to be a regular process used to knock out experts.
I'm going to see you and raise you, Judge Yates. I don't think I gave up predicting the future many years ago. But so I'm not going to necessarily predict, but I am going to suggest that no one who is tuned in, who is a valuation expert, has all that much to worry about with the changes in Rule 702. Because you're doing wonderful work, you're doing analytically rigorous work. You're not reinventing the wheel necessarily or inventing a new wheel. And I think that's what this new rule is designed to do. And tying with what Judge Yates says, not only, and what Melissa just said earlier, not only does it give the lawyers a checklist, hey, this is what I better ask for, it gives the judges a checklist. The judge is going to say, I find it more likely than not that Melissa Gragg has expertise in this area of business valuation. I find that she has reviewed sufficient facts and data. I find that she has used a methodology using whatever the methodology is, and that she's applied the methodology to the facts. It gives the trial judge the playbook. And the interesting question, and I'm not going to put Judge Yates on the spot, will be what the appellate judges will think of that level of analysis. So really, that's the prediction. I'd love to hear, but I don't think I want to even put Judge Yates on the spot either. So I wouldn't worry of the 163 folks we have on this panel. And thanks for joining us. I wouldn't lose too much sleep over it in your world. I think perhaps, the AI world and the AI world may become much more encompassing. The new science, if you will, might be more, might not put their head on the pillow in the same way tonight with the rule having been in effect for the last 17 days.
Yeah, and if I can just answer Judge Driscoll's question, because I don't mind taking it on at all, having been a trial court judge and now a judge on the Court of Appeals, appellate judges in this sort of circumstance are inclined to give a great deal of deference to the findings of the trial court. The fact findings are reviewed only for clear error. The exclusion of evidence or the refusal to exclude evidence is reviewed only for abuse of discretion. And so, although you can try to bind up some legal issues in there to try to get more exacting review, I think as a general rule, you're going to see appellate judges deferring to the trial court judges. So for you as experts, the whole game really, in my view, takes place in the trial court, not at the appellate level. So win it in the trial court, get permission to take the stand, and I don't think you have any concerns at all about having the verdict overturned on appeal.
Right.
Well,
Melissa, Janae just asked a great question about whether there'll be less emphasis on methodology and more on outcomes of the methodology. I think there'll still be emphasis on the methodologies that are being used. Again, the idea that if it's a new discipline, we want to make sure that it is a scientifically appropriate or peer-reviewed appropriate discipline. The addition of the rewording of D is another factor. Or an additional way of looking at subsection D, which is, again, the application of the methodology to the facts. But I don't think this is going to mean that there's any less rigorous analysis of the methodology. The methodology is really the crucible, and it will be examined, I think, continue to be examined very seriously by trial judges.
Well, and I think it's an interesting thing, because even if you don't have to worry about it, like even if you have probably followed everything, you will still maybe get this again, like you will still kind of get removed from court. I would have to say, like, if you're really active in litigation, the odds are you're going to get a motion in limine or motion to strike or a Daubert challenge or whatever you want to say. And the reality is you also have to be prepared to help the attorney either refute it, respond to it, and things like that, because this may or may not involve your, typically not going to involve your testimony. So it's all going to be back and forth. Do you think that there's any strategy for opposing counsel to be putting together that, motion eliminate or something like that for the expert, because it gives you a lot of information about where they're going, right? It gives you the issues that they have with you. I mean, it gives you a lot of information. Do you think strategically that's a good use of that motion?
Yes.
I worry a little bit about that, Melissa, because you hit the nail on the head. Every time I had a Dauber challenge, I would want the expert to come in and testify. For selfish reasons, as a trial judge, I wanted the expert on the stand explaining and defending what the expert was going to testify to. And that would allow me to make more solid fact findings to support my decision, which was almost invariably to allow the expert to testify. But you're right. If we have the expert testifying as a Dauber at a Dauber hearing, that gives the opposing counsel a free run at the expert to try to develop whatever they can develop during the course of cross-examination. So it's like a second deposition, but even better than a second deposition because you have a trial judge who's trying to direct the discussion. So I expect that these will be used more likely, more extensively, not so much to knock out experts who are qualified like you, as Judge Driscoll says, but rather as an enhanced form of discovery.
Right. And I don't see that as a necessarily a bad thing. Sitting in my seat and sitting in Judge Yates's seat, if we are the closer we are to the edge of our seats, the better we are as judges. The more we know about what the expert is going to testify, whether it's reading the motion limine or actually having a Daubert hearing, I think the better trial decisions we make, and then the better decisions we make after the trial is over.
Well, because it's an interesting theory. Like, if you really think that your position is good, I don't know if you would want to testify in the Daubert challenge. Yet, it also is bringing all of these issues to light in front of the judge. Like, in other types of litigation, you're going to have more hot tubbing, you're going to have more mediation, you're going to have more discussion. But in high commercial litigation, it's very regulated, right? And so in my mind, this is kind of an opportunity, A, to strategically see what the other side's coming at you for, if they do it, but B, you know, there may be some supreme benefit of you testifying in that hearing in order to, in my mind, kind of scare, you know, like, you've already probably done a deposition, but to also scare the other side that you are going to perform pretty well, right, in court. But is there anything that could harm me in choosing one way or the other? Because sometimes you have to encourage your attorney to go one way or the other, right?
Right. I think the biggest risk is not for you, the expert, but for your retaining counsel to screw things up. If retaining counsel doesn't take seriously a Daubert hearing and doesn't have you completely ready to go, you may wind up answering questions you don't want to answer. You may wind up creating confusion, not because of you, but because of poorly asked questions. Right. And then you have that record out there when you take the stand at trial. And anytime you testify under oath, you're potentially creating more conflicts in your own testimony, not because you're changing it, but just simply because the more times you have to tell something, a story, what your testimony is going to be, anything like that, the more likely it is there are going to be inconsistencies. So as you say, Melissa, there's a deposition first, then there's a Daubert hearing, and then trial. And so before trial, you can assume opposing counsel is just poring over the deposition transcript in your Daubert testimony to see where there are inconsistencies that can be exploited.
Well, and in some cases, I think that, you know, it's going to be very, you know, I've helped attorneys create these documents. I've helped them defend the position. And I think that if you are going into the hearing, you need to write your own questions. Like, you need to dictate how that line of questioning is going to go so that it's tighter than, you know, an attorney would do. But is the judge in these hearings, is the judge using this as a metric to know what the top issues are in the case as well?
Yeah, not only using the top issues in the case, but also using it as a vehicle for settlement. So there's Melissa testifying at the Daubert hearing, and she's doing great. And there's Louis the loser testifying on the other side, and Louis doesn't really know what he's doing. And obviously, those are both extreme examples. But I'm using that as a vehicle to try to, whether it's to hot tub you or whether it's to suggest what the resolution should be. I think if you are a prepared expert who knows what you're doing, I think you welcome that opportunity to testify to Daubert hearing. That said, as Judge Yates said, make sure you're prepared. And Melissa, I love the idea of an expert suggesting to the lawyer, hey, make sure you ask me about this. And when they ask me about X, Y, Z, here's what I think I'm going to say. I mean, that the idea of the engaged expert who understands not just her field, but understands the litigation process, I believe creates so much value to retaining counsel.
Yeah, I think you need to be writing your questions in general for any situation, especially testimony. But from my standpoint as a valuation expert, when I look at the amended federal rule, like, I don't see a lot of difference. Like,
Right.
I mean, maybe you all thought that was a big deal, but like, what else is it? Is it just like, I think maybe Judge Yates said, it's just an exclamation point of like, like even D, when you change the language, it's sort of continuing to circle back to the, can your position be replicatable, right?
Right. I would say this, Melissa. What concerns me most about the amendment of the rule isn't any substantive change, but just the change in emphasis that now tells trial court judges they're not taking these motions seriously enough, and they have to start taking them more seriously. Because first of all, as we've all been discussing, it engenders more motions. But second of all, it essentially creates a directive that a lot of trial judges, I think, will take to mean that they need to start disqualifying more experts. I hope it's not read that way, because it's not meant to be that, but I worry that may happen.
Well, then, and it's interesting. I mean, we have a few more minutes, because what I think it has happened in the past is it's like, well, we do this motion and it's like, oh, okay, thanks for doing this motion, but I'm still going to, compare it in the trial. Like, I'm still going to look at all the evidence. And it almost seems like, in some cases I've seen, opposing counsel actually use it to kind of try to pre-hear their case or pre-show that, like kind of get everything to go away. But we're also seeing it as just another hurdle, just another pain in our side that we have to get through. But to me, the experts don't have a lot of additional things that they have to consider. It's just, you have to continue to be mindful that it can be, that there's going to be more eyes looking at it, right? Or the judge has. So this is really more geared towards judges than the experts per se.
That's absolutely right. That's absolutely right. Now, and the one thing, tying into what Judge Yates said earlier, it may mean that you have yet one more time to testify. So, put in your retainer agreement, testifying at deposition is one amount, testifying at trial, and then testifying at Daubert or pretrial hearing, because that's gonna that there will be more of those. I don't know if there'll be a surfeit more, but there will be more.
Yeah. Well, and even reviewing it, because I've I think that in the past we've offered, through this presentation to include it in your engagement letter, like that somebody would have to notify you if there was a challenge logged against you. But even reviewing, like I want to review the response from our attorneys before it's filed. And that could go back and forth a couple times, because in some cases we're feeding them the information to go into that motion. So I just think that you can't sit back and allow the attorneys to run the show, because they're not going to know how to necessarily defend this, maybe in your nuanced situation, right?
That's exactly right. And it ties to something that when Michael Kaplan and Judge Yates and Judge Platt and I present, Michael always emphasizes the importance of, my metaphor is getting your elbows out and telling retaining counsel, hey, I'm not just someone to get up there in the witness stand or in the deposition or to give you a nice glossy report. I'm part of this process. I'm an expert. I'm not an advocate, but I'm part of this process and can help you as part of this process. And I think as Melissa said, it is so important to say that to retaining counsel. So this is another reminder. The amendment to Rule 702 is another reminder of the importance that you all play and should play with your retaining counsel.
And there's not necessarily, yeah.
I worry a little bit about what happens to you as experts if your retaining counsel don't take these motions seriously, because we've all sat through a qualification of expert witnesses before, and they'll say, how many times have you testified as an expert? And you'll say, well, I've been qualified 15 times. And that adds a patina of credibility to your testimony. Well, if more experts are getting disqualified because of Daubert, you can expect that on voir dire of an expert on qualification, the opposing counsel is going to stand up and say, isn't it true that you were precluded from testifying because a judge ruled that you weren't providing reliable testimony? And boy, if that's going to become a problem, you have to worry every single time you're challenged to make sure that you put your best foot forward.
Yep. Well, and I think we've come to the close for this. This was amazing. I think that, you got to stay on top of it and be with your, understand what your attorney is putting forth. But maybe Michael's going to give us some information. I know Judge Driscoll has to hop off for some amazing.
Before I hop off, I just want to say, this is an area of the law that Judge Yates and I are so excited about that we're both on vacation today. And we still wanted to be with all of you to talk about this. So we love this stuff. We really, really love this stuff. So Melissa, thank you for guiding us through. Thank you so much.
Yeah, thank you so much. We appreciate it. And Michael's going to join us for the next 5 minutes and, kind of give a perspective from maybe what an expert is saying. Thank you, Judge Driscoll. We appreciate it. Welcome, Michael. In light of what we've talked about today, how do you see this from an expert perspective?
Candidly, I see this as an opportunity for the experts to really establish themselves as experts. I've had the privilege of being challenged. I welcome the privilege because I know that when I'm on the witness stand in a hearing, in a motion to exclude me, if the judge will allow for an open hearing, I could establish myself as an expert who is responsible, who gives opinions that are well-founded, that I can communicate my opinions, that I haven't gone out to left field and I haven't gone out to right field. And the opposite of all of these things are those things that opposing counsel is trying to demonstrate. I've had the privilege over the past 3 or 4 years to be involved in cases, to be involved in matters that are dealing with some cutting edge technology for which opposing counsel and the opposing expert were able to come into the courtroom with with a substantial amount of discussion and opinions relating to other ways of addressing the valuation that were different from the way I approached it and would produce some substantially different numbers. But after that hearing, after the hearing on the motion to exclude me, each of the judges was convinced, was convinced that the approach that I took was the only way to approach it, and that each and every one of the suggestions that opposing counsel had and the opposing expert had were inappropriate in this case. So we can really, really establish ourselves. What have we learned from all of this? We need to be prepared. As experts, we need to be prepared. And when we walk into that courtroom, we better have complete control of our work, what we're doing, and be able to communicate it. And as someone who teaches communication in the courtroom, I cannot underscore the importance enough of being able to get up and to explain to people who are non-experts what we've done. Explain it in English, in a language that the jurors will understand and in a way that they can relate to it. First, we have the opportunity to communicate it to the judge when there is a challenge. I believe we're going to see more challenges. I think we should welcome those challenges. It's important that we have outstanding, just ongoing communications with our retaining counsel. Because when it comes to the response to a motion to exclude us, when I am the expert who is the target of the motion, I want to be in the driver's seat as to how the response is delivered. My retaining counsel knows going in that I consider this a very, very important issue. And this is not something that he or she should take lightly or attempt to respond to on their own, especially in the new world that we're in today with the update to 702, with the judges being reminded that they have to serve as gatekeepers. I will be there, at a minimum, I am going to provide my retaining counsel with a declaration that responds to that motion, with a declaration that answers those questions that I would expect to be asked if I was put on the witness stand, at a minimum. But I will also always encourage my retaining counsel to do whatever he or she can do to have the judge hold a hearing where I can get on the witness stand and persuade the judge that my opinion is well-founded. The methodology was the appropriate methodology, and that the evidence that I used was the appropriate and the best evidence, and that I approached it in a logical, well-controlled way so that my opinion is the logical product of applying good methodology to good evidence. But I want to drive that train. And then, assuming that the judge is going to give me the opportunity, which a judge usually does, and I think we're going to see more and more of that with the new rule, it just gives us an opportunity to experience opposing counsel.
Yeah, well, and I think you may have to suggest it, with your counsel, because they may not think that you're interested in doing that. So strategically, you also have to be a part of that conversation.
Absolutely. I agree with you 1,000%. The ongoing communication and openness and discussion of this particular step of the process is critical. It's really critical because we don't want to run around with a lot of exclusions, exclusions from testifying as part of our pedigrees, as part of our history. We want to be able to, we want to have, I don't mind being challenged, but I want to survive that challenge and I want to take control in that challenge. And I think it's a real opportunity for those of us who know what we're doing, who are prepared, and who work well with our counsel.
Thank you, Michael. And thank you, Judge Yates. We appreciate you staying on. If you have anything else to offer, I think Mel's going to push us along, right?
No, that's fine. I think we've covered the waterfront.
Okay, awesome.
Wonderful. Always a great segment. Thanks to all of you for this. And then we're going to move to our next segment. I'm going to introduce Janae, who's going to introduce the segment. It's a little different segment, and she'll set the context for it. Janae is a valuation professional that does a lot of work in corporate and personal goodwill with startups and creating systems and really doing a lot of work in the BV profession and everything. Janae, welcome aboard. I'll let you get this one started.
Great. Thanks, Mel. I had the opportunity to interview Simon ahead of the Fed's open market committee meeting, which was pretty interesting, maybe a good case study in the known and knowable that Michael was talking about with Hitchner earlier, where we're required always as business and valuation experts to provide a reasonable analysis and not necessarily to have a crystal ball and apply what is known or knowable at the date. The valuation date. So interesting exercise. I asked Simon about the new normal for interest rates, as well as getting kind of a wrap up for 2023. So with that, I will let the video play and hope you enjoy. All right, thank you. Simon Rubinsohn is the chief economist at the Royal Institute of Chartered Surveyors, RICS. He joined RICS in July 2022 after serving as senior strategist at Barclays Wealth, where he was part of a team responsible for running the multi-manager investment portfolios and helping to develop structured products to widen the client offering. Rubinsohn is a well-known economist who has been quoted in various publications such as The Guardian, The Financial Times, and Wall Street Journal, as well as many others. He has also appeared on BBC News and Sky News as an expert commentator on economic issues. In his current role at RICS, Rubinsohn is responsible for leading the organization's research and analysis of global property markets. He is also responsible for providing economic analysis and forecasts to RICS members and external stakeholders. In addition to his work at RICS, Rubinsohn is a member of the Treasury Committee of the House of Commons, and he also does work with a nonprofit looking into homelessness issues. So Simon, it's so good to have you here and to get an update.
Nice to be here.
Great. So we're wanting to look at an update for 2024 as we're rounding up 2023 and what we're expecting as we approach the new year. So first of all, I would like to ask you, what do you make of the expectations or some of the projections and forecasts that in the US, the Fed is expected to lower interest rates, maybe as early as March 2024? What do you make of this?
Well, look, I mean, 2023 has been an interesting year in many respects, and in part of that has been that the much talked about recession, whether it was in the US or elsewhere, never really materialized, and part of the response to that was that interest rates were pushed up higher than perhaps was envisaged at the beginning of the year. And as we move into 2024, the speculation begins to build. It does seem that we've reached the top of the cycle, but perhaps markets are beginning to run ahead of themselves in the anticipation, not just in the US, but elsewhere, that not just the next moves down. I think that probably there's a pretty firm consensus that that is indeed going to be the case. But that timing issue really becomes quite a critical one. And then also trying to understand where or which central banks are likely to move earlier. When it comes to the Fed, I'm certainly concur with the view that March seems a little premature. When I look at the economics, and that these things are evolving, but when I look at the economics, I don't see an environment in which the economy is so sort of vulnerable, and where inflation is at a level that I can see the trigger being pulled within a couple of months or so. If we look back even to the recent employment data in the US, we can see a set of stats there which are still quite mixed, but on balance suggest that the labour market is relatively resilient. I use that word again. That wage growth is probably at a level that is slightly above where the Fed would see as being compatible with its target for inflation. And as a result, I think it would need more evidence before wanting to send such a strong signal to markets. So I don't think the Fed will be going, at this point anyway, I don't think the Fed would go in March. And I'm actually not sure the Fed would be the first of the major central banks to pull that trigger.
Who do you think would be?
Well, I actually think that possibly the European Central Bank may have more justification for moving. When I look at the balance between the euro area and the US, and I look at the macro fundamentals, I see in the euro area more evidence that the economy is under pressure. As a sort of an aside, and I don't like to focus on technical recessions. Economists often talk about 2 quarters of negative growth being a technical recession, but that in itself is pretty meaningless in many respects because it could be distorted by all sorts of factors. But nevertheless, the euro area economy shrank in Q3. Germany and France, the two biggest players in the euro area, saw their economies shrink in Q3. Italy was fairly flat. So that's the big three. So it's not difficult to envisage, in this very specific definition of what is a recession, the euro area actually entering 2024 being defined as being in a recession. On top of that, I think there's more evidence that the labor market perhaps is a little softer in parts, certainly in parts of the euro area. And that, if that is indeed the case, and if energy has, the role that energy is playing in underpinning core inflation has been greater. So as that energy price comes down, it helps ease some of those core inflationary pressures in a more pronounced way, then I think that the ECB might actually be more prepared to sanction easing policy. And in fact, I think one of the things you've seen in recent weeks is some ECB policy makers actually soften very publicly their position on the outlook for monetary policy. I think the Fed's been a little bit more clearer in trying to hold the line.
Okay. So what do you think expectations should be for 2024? Goldman Sachs predicted that, and it's kind of funny to say, so Goldman Sachs predicted that the economy may outperform in 2024, as you mentioned, the economy had done in 2023.
I'd love that to be the case, Janie. I think that most people on this call would love that to be the case. I mean, there would be some interesting opportunities that would emerge. But I think it's still going to be a pretty hard year. When we talk about outperforming, quite often we're talking about sort of decimal points, on numbers. And it's for many practitioners, economists love this stuff, of course, and I love it. But for practitioners out there, 0.1 or 0.2 or even 0.5 difference from a consensus doesn't make an awful lot of odds. And I suspect that, certainly the early part of 2024 is going to be a bit, challenging. I think you've got a legacy still of, policy tightening may have been officially sanctioned, but the way it comes through and impacts households and corporates often is in a very different way, and you can find the lagged impact of policy tightening taking a while to really to bite. And I suspect that those factors will be relevant in 2024. I think on top of that, some of the fiscal stimuluses, the way that governments have been acting, partly legacy of the policy measures introduced in the wake of, exiting, I suppose, COVID. Some of those measures on both sides of the pond are going to be slightly less supportive of growth in 2024 than 23. Now, none of that means we won't have another resilient year. None of that means we're going to have a hard landing. We're not going to. I'm pretty happy with the idea that the US economy will continue to bounce along, and it will not be a significant dip down. But I think if you look at the headline growth rates, 2024 probably won't be that different from 2023. And maybe if you actually look at the numbers, partly because of base effects, they may actually be slightly lower on balance from 2023. So look, I take on board the Goldman's view, and we are always hoping that we're going to get some sort of positive exogenous shock, because we've had quite a few negative ones to contend with over recent months, and it may be that does indeed help us. But I'm sort of I don't want to be sort of the bringer of sort of a negative tone to this this session. But I think on balance, I'm a little bit cautious still about how certainly the first half of 2024 is going to pan out.
Right, and I think if anybody's interested, you did a really great job explaining how the impacts reach the consumers and households in our interview back in June. So if anybody is interested in that, go find that recording, because I felt like that was very illuminating back in that interview. It's worth a listen.
Thank you.
So we've talked some about Europe, the US, and maybe how you don't expect a hard landing there, but what economies do you expect to be most vulnerable to recession and more difficulties going into 2024?
Well, I mean, I sort of suggested that I think that Europe is perhaps on the more vulnerable end of things, and it doesn't necessarily mean it's going to be anything other than sort of a fairly flat environment during the first half, but it is a bit more vulnerable. And if we look further afield, you might say, and again, it's not about recessions as such, it's about where performance will be against expectations. If you were, for example, to look at China, the focus on that 5% growth target is a challenge for policymakers there. They probably are going to come close to it this year, but I suspect that the continual sort of pressure from sort of developments in the property sector, high debt levels, challenges for local government are all going to continue to weigh quite heavily on the Chinese economy. And on top of that, you still got this ongoing political and economic sort of fragmentation between China, the US, Europe, and that sort of has ramifications potentially for trade flows. So putting all that together, it wouldn't surprise me if China, from an economic point of view, disappoints slightly in terms of its growth outlook. Again, not really thinking about sort of a hard landing there, which I'm sort of thinking about growth, closer to 4% than 5%, and it's all about relatives. I would suggest that there are some, interesting positive stories out there. And perhaps, when you look at, they're not necessarily in the more advanced economies, but if you look at India, for example, policy there has been quite successful in crafting an economy that is, dynamic, and it's got a really good underlying fundamental of a, growing population in contrast now to China, quite a young population, and that's sort of, fitting in with the industrial narrative around India, which is much more service orientated and benefiting from some of the big global trends. So India looks a really positive story, and that's likely to continue. And I would also highlight some of the trends in the Middle East. And by Middle East, I'm looking very much at the Gulf area, where we're seeing likely to see continued strong performance from the likes of Saudi and UAE. They're obviously benefiting in part from what's happened to sort of oil prices, although they haven't had another leg up, but they're obviously benefiting from the revenues there. But there's a lot else going on, which is quite interesting as a positive story.
Okay, very interesting. Are there any things that you can pick up to share that India is doing well that we can look for if, say, we're looking at American policy, European policy, if we're looking at valuations of developing companies in developing nations? Anything that you'd want to point out for us?
I think the thing about India, obviously, you're trying to apply what's happening in an emerging economy is difficult to sort of, it's difficult to play that out in a more advanced economy. Just the nature of the industrial structure, the population mix, it is a very different environment. So I wouldn't say that there are immediate lessons there for sort of advanced economies, but clearly into thinking about what actually drives economic growth. Advanced economies have got to be very much focused on this whole issue of productivity. It's an ongoing issue, and it chimes with one of my more sort of hopeful stories for 2024. How does AI play out in terms of supporting the wider economy? I mean, we're sort of torn on. It's slightly schizophrenic here. We're sort of scared of what we see, and then we're hopeful of what we see. And I suppose harnessing technology in this way to help perhaps craft a more positive environment for the wider economy is something that could be the big driver for growth. Not really necessarily just not perhaps a 2024 story as a segmented sort of theme. It's obviously something that is multi-year. But we could begin to see some of it begin to play out next year, and focusing on that. I think another positive area, focusing on the green story, green investments. these areas could be quite big drivers for productivity and for growth more generally then, and help set sort of what we describe as the advanced economies on a better medium term trend for sort of raising both growth and inevitably obviously living standards, and more relevantly of course, if creating a more positive environment for business valuations.
I'd like to spend, if you don't mind, just our last few minutes talking about what you think maybe the new normal for interest rates, for the Fed funds rates, and how that impacts our valuations.
Look, this is a fantastic sort of issue to discuss, because, we've all been sort of living off the back of really cheap and easy money. I mean, I know that doesn't always play out directly for many businesses and some households as well. But, when interest rates are effectively zero, it's interesting, and it does create opportunities. I think if anyone that looks at long-term trends would acknowledge that these are unusual periods. The difficulty is getting weaned off the belief that interest rates should settle back down at the levels, and understanding what is a more realistic proposition and what that means for valuations, what it means for business valuations, what it means for real estate, etc. Now, I mean, I would look at sort of the focus on trying to achieve a sort of
We lost part of the video.
Are you starting that again, Shanda, or?
Let me try to
I
pull it
think-
quick, and then I can start it from where we ended off. So, once again.
Great. We will wait. If not, we have Michael Mulder with us.
Give me one moment. I think I'll start from right here. I was able to hold back up, so give me one moment and I'll start it over.
Okay.
create opportunities. I think if anyone that looks at long-term trends would acknowledge that these are unusual periods. The difficulty is getting weaned off the belief that interest rates should settle back down at the levels, and understanding what is a more realistic proposition and what that means for valuations, what it means for business valuations, what it means for real estate, etc. Now, I mean, I would look at sort of the focus on trying to achieve a sort of targeted inflation, generally put at 2%, give or take, in most of the major economies. How they define that is up for grabs, but generally 2%. And if we build on top of that a trend rate of growth for the economy somewhere, hopefully somewhere around at least 1%, perhaps a little bit more, I think that gets us into the ballpark of where you might say a neutral interest rate would be. So something between 3 and 3.5% would not seem unreasonable to me. Now, that doesn't mean that rates won't go below that, and we know over the course of a cycle they will. But if we work as a core proposition, that helps us to begin to think about where we should be placing valuations. Whether it is, as I say, for businesses, whether it's for real estate, and I think that that does provide scope for some positive stimulus over the course of the next 12, 18 months in terms of lower rates. And that is a reason for encouragement. But I think it's really important that one thinks about, whether it's risk management, whether it is, valuation, that one understands that, in terms of the cyclical pattern, it will take something quite extraordinary to get rates, significantly below that. And that, I think, is something that's a real caveat when we try and build in, we think about a multi-year period of monetary easing, what that actually should mean in terms of how we actually place our bets on where values might go to.
Great. Sorry about that. This is wonderful as always. I appreciate all the things that you're able to explain in a very quick and digestible format. So thanks for giving us a wrap up of 2023 and what we can expect for 2024.
Okay, now we're back. We have our next polling question. That's number 4 for all of you. Thank you for your patience with the video. But now we're going to have Michael Mulder. He's going to talk about valuation verdicts and federal and state case law summaries. Michael Mulder is one of our correspondents. He's with us every other month talking about case law, and that's really important for us. So, Michael?
Yep. Hopefully I properly unmuted myself.
Yes, you are. You did.
Okay. So that's me. No one's there. So the case we're talking about this week or this month is called In Re Hussein. It is a divorce case coming out of Illinois. This was an appellate decision, so you got to sort of take that into account. Mostly because at the appellate level, especially in divorce cases, there is a great deal of deference given to the trial court in its role as fact finder. And so the appellate court deals with issues mostly in terms of interpretation of law. So the key issues in this case involved witness credibility and the value of husband's business interest and the sufficiency of evidence in terms of talking about the value of the business. A great deal of time in the opinion, or great deal of space, I guess, in the opinion is addresses the children of the marriage and custody and issues related to husband's role in the children's upbringing. I'm not getting into any of that, just so you know. So the parties were married in July of 2004. Husband filed for divorce 3 days after their anniversary in 2021. 4 days after their anniversary in 2021. Like I said, a lot of the issues in the opinion deal with the minor children and what's to be done with them and who's got custody and all that stuff, none of which are related to the things we deal with. The marital estate was relatively small. There was some retirement accounts. There actually was an investment account that needed to be divided. There was the marital home and a second property that they had that they were using as a rental property, and then husband's business. Early on, the court granted sole possession of the marital home. This was not the equitable distribution decision, but actual possession of the marital home was given to the mother or the wife, so that the children would have consistency in their lives. Parties did not dispute the value of the home was $340,000. Husband was ordered out of the home because there were issues of abuse and arguments and behavior that was troubling to the children. And so the husband was directed to move out of the house. And what he did was, instead of renting a place, he took possession of the rental property. And that was only pending the divorce proceedings. The intention was that they would sell that property once the divorce was finalized and then split the proceeds. And both sides were fine with that. The investment and retirement accounts were divided by who had title to them. That gave $63,000 to husband and $95,000 to the wife. Again, relatively small amounts. The big thing, and other than the child custody and child welfare issues, the big thing in this decision was the valuation of the husband's business. Wife retained a valuation expert who was unable to get documentation from husband for a lot of the information he was looking for. Husband either did not have it or refused to produce it. I don't know which. Among the things that were included in the testimony, wife had testified that in 2017, the husband told her that his business was worth $2 to $3 million. And in 2018 or 2019, he said it was worth $8 million. None of which is relevant really because, the court addressed it. It's not actually relevant because A, it's hearsay, and B, neither one of them is qualified to opine on the value of the business. So what the business does, it does software consulting services, and the court, which I assume got it from the parties, uses the term pre-funds gift cards. And what that meant was that the husband's customers would negotiate with him to acquire gift cards for distribution. And so they would give him a bunch of money, and that money would sit in the corporate bank account until it was spent on the gift cards or refunded to the customer. And husband's claim was that none of this was income to the company. He also testified that the company had borrowed $33,000 and change from his cousin in 2017. There was a promissory note that said the interest was going to be 15%, dating back to January 1, 2017. And it was due on January 1, 2022 or on demand. And so this was a bench, as almost, as far as I know, every jurisdiction, all divorce cases are bench decisions. And it took place over a period of several months. In his initial testimony, he said that there had been no payments made on the loan. And then later on, in later testimony, he said that in December of 2022, he paid $45,000 as a partial payment. He also testified about an SBA loan that was taken out as part of a COVID relief program. And he produced a loan authorization letter that provided for a $150,000 loan with payments beginning in September 2020. But they never actually could produce any documentation related to the loan itself. At trial, he talked about it. He said he remembered getting a letter saying that he would have to start making payments, but he had no idea what happened to the letter, and he never actually made any of the payments. So this is an appellate decision. It comes up de novo review on all legal issues, but on factual issues, the only way the appellant can prevail is by establishing that there's clear error on the part of the trial court. And so on the valuation side of this, because again, the court dealt with a lot of child custody issues that were really substantive, but the valuation was all factual. And so the trial court had found that wife and the guardian ad litem who was appointed to protect the interests of the children, their testimony was competent and reliable. The husband's testimony, on the other hand, as quoted in the trial from the trial court's opinion, that based on his demeanor and while testifying and repeated attempts to interrupt and provide information beyond that called for by the question, court decided that he was not reliable at all. So in the absence of an expert valuation or reliable testimony of the business value, the trial court entertained its own valuation. And it came up to $191,000 based on bank statement showing cash on hand of about $194,500 and a credit card balance of $67 owed by the company. And quite frankly, there is no explanation for why $195,000 in cash turned into $191,000 in value. Appellate court didn't deal with it. I did not see the trial court ruling. And so the trial court completely disregarded any of the husband's claims about the business debt, both to his cousin and on this supposed SBA loan, because it was his claim and he produced no evidence to actually support any of it. There were no financial records. There was no documentation of the loan. There was no of either loan. And setting aside, the court didn't address this, but I'm looking at it thinking a 15% interest rate on a loan from a cousin between cousins seems pretty extreme. So you got to really wonder what the reality was in that transaction, if there was a transaction at all. Court also disregarded husband's claims that $194,000 of cash on hand was not really his, didn't belong to the company, but it was advances from customers awaiting either refund or expenditure on gift cards. And my time is running out, so I got to finish quickly. And again, the absolute lack of documentation for any of this stuff made the court suspicious when it added to the general lack of credibility of the husband's testimony. So in terms of takeaways, and you know, I understand that in this case I'm preaching to the choir, but it's worthwhile for those of you, especially those of you who are involved with divorce lawyers, and you want to talk about situations like this. Documentation is critical. Without any kind of documentation, the court is left to sort of dubious personal testimony, and you know, the judges don't really give that a ton of credibility. And witness demeanor, which in a divorce case, the parties to the case are almost inevitably problematic witnesses, and as a result, it really is important to have a professional valuation done. And even if the evidence is limited, it's worth having an expert who can come in and say, well, this is the stuff that we would expect to see. This is the stuff, this is the information I needed to conduct this valuation, and that stuff was missing. And that's pretty much the story on the Hussein divorce. That's my contact information. I believe, although I'm not certain that it's there yet, because I only sent this case in, I think, a week or two ago. The case will be on the Key Value Data website. Excuse me. But if it's not, shoot me an email and I'll send you a copy. It's a fun read, if nothing else. And
Michael, thank you so much. I mean, you're exactly right. This whole idea of I never did a lot of family law, but it is certainly entertaining to see how these folks conduct themselves at trial, before trial, and how it all goes about. Oh, you muted yourself.
No, I'm here.
All right, there you go. Yeah. So I appreciate it. It's always fun to read these things and say, what were they thinking?
That is truly the case. And it's always the fun ones that I use around the valuation. So
great. So great to have you, my friend. Have a great holiday and everything. And we'll see we'll see you in the coming year.
Yep. Have a good one.
All right, man. With that, well, let's bring on Brien Jones. Brien, so good to see you again. Saw you last week. And Brien is going to spend a little time with Michael Hill talking about E&O insurance and protecting our practice and protecting our business, possible additional member benefits and things like that. So, Brien, I'm going to hand it off to you. I think you're muted.
Sure was. Now, better? Excellent, and glad to be here. Thank you all for joining us. Our guest for this last segment on this month's program is Michael Hill. I think Michael's joined us. See if we'll get his camera going here. Or Michael, are you hearing us?
Yeah, I'm hearing you. Sorry.
Excellent. Thanks for joining us today.
Yeah, thank you.
NACVA is pleased to offer a partnership with 180 intermediaries, Hill program managers, to extend errors and omissions insurance to our membership. We're pleased to have Michael Hill, who is the managing director of 180 intermediaries, joining us to talk a bit about the program, the benefits, and the reasons why you should consider having this type of insurance and how to get enrolled in it. So, Michael, tell us a bit about 180 intermediaries.
180 intermediaries is part of a larger group called Access Risk Management. About 5,000 employees nationwide, a couple $2 billion in revenue. And we're a small division of that company. They've been in business for quite a while, one of the larger brokers in the United States.
What is the purpose or the importance, rather, for our members to consider having E&O insurance?
Well, I think there's a few things. Everybody knows that the business can be a little bit litigious. There are quite a few attorneys in this world, and they need something to do. Excuse me, I have a cat trying to join me. When a suit is filed for some kind of error or omission, the first thing that anybody's going to need is defense. So importantly, one of the most important pieces of the policy is that it provides for defense. We have an excellent group of attorneys who manage our claims out of Chicago, and they're very familiar with what we do. And they have a whole panel of attorneys, defense attorneys, that they can go to. So that's a really important piece for it. A lot of people find that their clients are requiring professional liability, general liability, things like that. So it's important for them just to be able to get on the job, which is, critical for all of us, right?
Right.
And then, of course, in the end of it, there's being financially capable of paying a claim. A policy with $1 million or a $2 million limit probably going to provide a lot more financial security than a lot of us can come up with out of our savings accounts.
Can you speak a bit about the different types of plans?
Well, the policy is underwritten by Lloyd's of London. We have the authority to underwrite the policies here in our office. The professional liability policies are typically, 99.9% are claims made policy forms. Limits of liability starting around $1 million. $2 million is easy. We can obtain $5 million in limits for people. It just depends on the size of the company and the types of requirements by their clients. Then our policy has a very broad definition of professional services. So business valuation, mergers and acquisitions, consulting, things like that are all included within the definition on our policy.
What are the steps, or what does it take, what's involved, rather, for our members who are considering exploring a plan through you all? What is the process like? What can they expect to go through if they were to contact you and your team to get things going?
Sure. Almost every insurance program starts with an application. So we have a specific application to this line of coverage that we write. It's only about 4 pages long, maybe 20 questions. It's a PDF format, fill in the blanks, sign your name digitally on it, and submit it through email. It's really very simple. Typically, we will then go to the website, look at the website. We'll go to LinkedIn, look at the various profiles on LinkedIn and resumes, and that helps us determine if people qualify for the program or not. So it's really not a very difficult process at all if somebody's interested in just finding out what it would cost or how it would work for them.
Sure. I have a question for our audience, the 158 people who are joining us still. My question for you all who are joining us, and if you wouldn't mind responding in the webinar chat, and that is, do you currently have an errors and omissions plan in place? If you do, please enter yes. If you don't, please enter no. And Michael, what would be, for those who have a plan, is it that they can consider another plan and maybe join over to this one? And for those who are responding no, what would be your advice to them to consider, or your thoughts to them to consider your plan?
All right. Well, first, if somebody already has a plan in place, they have a professional liability program. Maybe it includes general liability and cyber liability. Then the important piece for them would be to look at their expiration date. So when does it come up? Maybe January 1st. That's a very common expiration date. July 1st, very common expiration date. At maybe 60 days prior to that date, try to pull all your stuff together, get your policy forms together, take a look at, do your accounting, take a look at your revenues and things like that we're going to need to evaluate the program, and then contact us maybe 30 or 40 days ahead of the expiration. If you don't have a plan in place, your second example, then they can contact us at any time they want. And we can work something up very quickly for them. Like I said, we have the authority here in-house to do the underwriting.
Looks like we got a
the pricing has been prescribed by London. So those are the two ways that'd be best. Trying to look at something midterm is very difficult. Underwriters aren't very happy about looking at a midterm move. Usually not an indicator of good things.
Mm-hmm. So it looks like we've got, from those that responded, about 50-50%. Some have policy, some do not, and it looks like some may not have it for errors and omissions, but malpractice only. Is that part of the plan that you all are able to extend, or?
Yeah, the words malpractice and errors and omission are used interchangeably in the insurance world. Sometimes it's called E&O, sometimes it's called professional liability, sometimes it's called malpractice. You find malpractice being used more in the medical area of professional liability.
You were speaking about the benefit in pricing that's extended to NACBA's constituency. Can you speak a bit about that?
Sure. We have two things that we can provide for NACBA. If somebody is a member, then we're able to put an endorsement on, and we've negotiated with Lloyd's of London that helps them with their deductible in the event of a claim, and provides good monetary benefit to them. The other benefit we have is if somebody has a designation, then we're able to provide them with the endorsement that provides the benefit of the deductible to help, and also a 5% discount off the premium.
Excellent. So we've got your contact information on the slide that we're showing here, Michael, your email, your phone. Those are the best ways to get in touch with you?
Yeah, those work perfectly well.
Any closing words on this plan and benefits or other considerations you'd like to share before we exit?
We're really proud of this, and we've been doing it for several years now. And we work with NACBA and, of course, 3 or 4 of the other associations in the industry. We have a long-term relationship with Lloyd's of London, going back well over 25 years. And we also have an excellent relationship with our attorneys that handle the claims. It's DWF claims out of Chicago, and the attorneys there are really wonderful. They've always done a great job. And then I might also mention that we're also able to provide some general liability coverages, and importantly nowadays, cyber liability. We've had some interesting cyber claims.
Are you able
but
to
that's
maybe...
another topic.
Sure, yeah. We have a question. What about tail or prior acts coverage if you move from your current plan?
Typically, in professional liability, if you're moving from one plan to another, the carrier that is taking over your coverage will honor your prior acts. So if you had started your program, say in 2016, had renewed it every year, then the new carrier will give you what they call a retroactive date of 2016, so that anything that has occurred between 2016 and now can be covered by the policy.
Thank you for that. And I'm going to put in the chat for everyone the link to NACVA's website where you can learn more about 180 intermediaries. Just put that in the website, nacva.com/business insurance. It includes an overview of how to get in touch with Michael and also to reach him for further questions. If there's nothing more, Michael, another question for us. Is defense cost in addition to the stated coverage amount?
Typically not. Defense cost is typically included in the limit of liability. There may be an opportunity to buy some additional defense costs if it's required by a contract or something like that. But in almost every case in this industry, the defense will be what they call inside the limit.
Thank you for that. Any other questions from our audience? Next question, how quickly can we get underwritten? I have a plan renewing January 8th.
Because we have authority here in the office, it only takes us a few days. So we can accomplish that goal without any problem.
Excellent. Any other questions from our audience? All right. Well, Michael, thank you so much. We're pleased to be working with you on this very important program for membership.
Thank you for this time. I very much appreciate it.
You're welcome. Okay. And it looks like with that, Mel, Alina, and Chinda, we've concluded our last show of 2023.
How did we get here so fast?
I know, and it's a wonderful attestation to the correspondents who support the show from month to month, for engaging with all the experts we bring on. We're so honored and pleased to have so many folks wanting to jump on this program and share their expertise. Thank you both, Mel and Alina, for being our wonderful hosts. And of course, behind the scenes, Chinda Chuan, making all the magic happen in front of and behind the scenes, coordinating with everyone. Thank you all for joining us as well every month. Any closing words?
Thank you, Brien, for kind of getting this rolling and doing it with Alina. And I know we've got another great program coming in January. We'll keep doing. We're looking for new ways to improve and grow even more so. January 22nd is our next program.
Yes.
With that, I'm just going to wish everyone a wonderful holiday season, new year, and all the health and blessings that y'all deserve.
Happy holidays, everyone.
Yes, happy holidays.